Hi there, I'm Caroline Cobain, Legal Director at Just Employment Law. I was talking to a new client today about whether it was appropriate to include a probationary period in the new contract that I was preparing for them. Probationary periods are not required by law, but they are often helpful in that early stage of an employment relationship to assess performance and conduct and to make sure that the hire is right for your business. Often, notice arrangements and benefit entitlement changes at the end of a probationary period, so it's important that the contract signposts the arrangements for the end of the probationary period and confirms arrangements for when the employee will be told whether they have passed or not passed the probation. Some employers decide not to include probationary periods in their contract, and that's fine. Often they think it's appropriate to do so because the employee doesn't have the right to bring an ordinary unfair dismissal claim in the first couple of years of employment. But in that respect, it's important to remember that there are some other claims that employees can bring early on in the employment relationship, and the probationary period can sometimes be a good way of testing other aspects of the relationship if it's not going to work out the way the employer has envisaged. Regardless of whether or not an employer decides to have a probationary period, the contract should set out whether the probationary period applies or not, and if it does, how long it's going to last for, and whether the employer has the right to extend it. If you need further input on probation, give us a shout and we can help you with that.